A Maine transfer on death deed authorizes a grantor to convey property to a beneficiary effective upon the grantor's death. This document streamlines the transferal process, allowing the beneficiary to forego lengthy probate proceedings. In this video, we'll cover the difference between a transfer on death deed and a will, legal requirements for recording a transfer on death deed in Maine, and how to revoke a Maine transfer on death deed. We're eForms, the world's largest online database of fillable legal forms, and we're here to explain and simplify complex legal processes you may come across in everyday life. To begin creating your own Maine transfer on death deed, click the link at the end of this video. Let's begin by discussing the purpose of a transfer on death deed. How is it any different than a last will and testament? Generally speaking, wills and transfer on death deeds are similar because both can be used to bequeath property to descendants. However, the key difference is that a will is subject to probate while a transfer on death deed is not. If you're unfamiliar with probate, it's the legal process of determining a deceased individual's assets and then distributing those assets. Though this sounds simple enough, probate proceedings can take anywhere between 9 and 12 months. That's why transfer on death deeds can be so helpful. Next, let's talk about how you complete a transfer on death deed. Fortunately, the form is very straightforward. It will request information like your name and the designated beneficiary's name. But one piece of information that can be difficult to find is the legal description. A legal description specifies the plot's exact location and boundaries using cardinal directions, distances from key landmarks, block numbers, and other unique identifiers. If you're having trouble finding this information, reference your property tax statements or current deed. You can also request a legal description from the Registry of Deeds in the county where the property is located. Once you've completed the form, the next step is to get it notarized. Then you'll take the form to the Registry of Deeds in the county where the property is located so it can be recorded. Keep in mind that the transfer on death deed must be recorded before the transferor's death to be valid. Okay, so let's say you record a Maine transfer on death deed, but now you need to revoke the deed. Is that possible? Yes, you can revoke a transfer on death deed at any time before your death. You can do so using one of 3 documents: a new transfer on death deed, a revocation form, or an inter vivos deed. These documents must be notarized and recorded by the Registry of Deeds in the county where the property is located before the transferor's death. Of course, talking about your own death isn't the happiest subject, but by taking proactive steps and completing a transfer on death deed, you can ensure that your legacy is protected. To get started on your own Maine transfer on death deed, click the link below. And don't forget to subscribe for more helpful content.